Hi, Jim Solbach. Today I want to talk about damages in willful violation litigation. And the question is, are actual damages required? Now, there are some courts in parts of the country that say you can't bring a willful violation motion unless there's actual damages. I think that's wrong. Are actual damages required? No. Why is that? Well, here's what one New York court said. Section 362H, which is now 362K, authorizes damages in the form of attorney's fees incurred by a debtor asserting its automatic stay rights, even if there are no damages apart from attorney's fees. So most courts will award sanctions and attorney's fees even if there haven't been damages. Now, what are the damages in a willful violation motion? Well, it could be maybe they took money out of the debtor's bank account, maybe they garnished the wages, or maybe there are emotional damages. But courts have kind of a hard time with that. So someone who is kind of upset, how much is that worth? It's really a tricky thing. But to say you didn't have emotional damages, or they didn't take money out of your paycheck, so there's no violation, cuts across the whole purpose of a stay violation. That's why the purpose of stay violations is a deterrent, not only to protect the debtor and to protect the integrity of the system, but act as a deterrent. Look, if there's not going to be any consequences, why should creditors care? I mean, if the only thing that's going to happen is they're going to get a nasty letter from some debtor's attorney, it's not going to cost them any money, then why should they do anything to try to curtail stay violations? Now, that's not true under the FDCPA. Companies spend millions of dollars making sure that they comply with the FDCPA. Why? Because in that body of law, lawyers do sue, and these people have to pay damages for violating debtors' rights. It doesn't happen as much in our field here, and I think it's because for so many years, creditors just feel like there's really no consequences. Why would they spend money training their employees when nothing really happens? Now, there was a case in front of Judge Littlefield many years ago, which just fascinates me. The creditor is a bankruptcy attorney who freezes the bank account of the debtor knowing that the debtor had filed. Judge Littlefield imposed sanctions and damages. Then he does it again. This time the debtor again comes in and files a 362K motion, and again Judge Littlefield imposes damages and sanctions. This time the creditor appeals to the district court, and the district court takes what I call the no harm, no foul approach and said, well, you weren't damaged, so there's no violation. Well, what message is sent by that? You can do whatever you want. You can freeze their bank account, you can take their money. If there's no damages, there's going to be no consequences. That cannot be what Congress intended. So that's why you don't need actual damages for a willful stay violation.